Imagine standing in an Egyptian village more than 3,000 years ago and hearing a marriage collapse next door. There is no courtroom packed with lawyers. No priest announces that the union has been dissolved. No government office produces a modern divorce certificate. Yet the husband may be ordered to return property. The wife may leave with goods that belong to her. Witnesses may be summoned. A written agreement may be read aloud. And before long, both former partners may be free to marry someone else. This is the part of ancient Egyptian life that rarely appears beside pyramids and golden masks. The Egyptians did not only prepare for death, they also had to solve painfully familiar problems among the living. What happened when a marriage failed? Who kept the house, the grain, the furniture, and the valuables? Could a woman control property without her husband? And if a parent believed that some children had abandoned them, could those children be cut out of an inheritance? The surviving evidence gives a surprising answer. Ancient Egyptians could divorce. Women could possess, transfer, and inherit property. Couples could make financial agreements that anticipated separation. And some people could redirect or even deny parts of an inheritance. But none of this worked exactly like a modern legal system, and the rules did not remain identical across 3,000 years of Egyptian history. To understand what really happened, we have to leave the palace and enter the household. For most ancient Egyptians, marriage was first of all a social and economic arrangement. In many periods, we have no evidence that an ordinary marriage required a religious ceremony or a state official to make it valid. A man and a woman established a household, lived together, and were recognized as a couple by their families and community. Egyptian expressions connected with marriage could describe taking a spouse or establishing a household rather than completing a single sacred ritual. That does not mean marriage was casual. A household was an economic unit. It produced food, raised children, managed land or wages, stored textiles and grain, and maintained obligations between relatives. The moment two people lived together, property and inheritance became serious questions. The evidence also changes depending on the century. Documents from the Middle Kingdom can show transfers of property within a family. Records from the New Kingdom village of Deir el-Medina reveal household disputes in unusually vivid detail. Much later demotic marriage agreements, especially from the late and Ptolemaic periods, often spell out financial obligations more formally. We cannot take one contract from the 2nd century BC and pretend that every Egyptian couple followed the same formula in 1500 BC. But across the evidence, one principle appears again and again. Property rights mattered, and they could be documented. An Egyptian wife did not automatically disappear into her husband's legal identity. Women could own goods, inherit property, make transfers, bring complaints, and appear in legal documents. Their real power still depended on wealth, family connections, local custom, and access to scribes and witnesses. A poor woman and an elite landowner did not experience the system in the same way. Even so, the legal capacity visible in Egyptian records is striking. Now imagine a marriage ending. The surviving texts suggest that divorce could begin when one spouse left the shared household or when the couple formally acknowledged that the relationship was over. Either partner could potentially initiate separation. Adultery, conflict, infertility, neglect, or the desire to form another marriage might all lie behind a breakup, but the surviving record is uneven. Ancient documents were usually written to settle property and obligations, not to preserve every private emotion. There was no universal Egyptian equivalent of today's no-fault divorce form. In one period, a spoken declaration witnessed by others may have mattered. In another, a written document could protect the parties from later claims. The essential problem was not simply announcing that love had ended. It was untangling the household. That could become expensive. In later demotic marriage contracts, the financial consequences of separation might be arranged in advance. A husband could acknowledge property or money associated with his wife, promise maintenance, or agree to pay a specified sum if he rejected her. One marriage contract now in the British Museum, dated to 172 BC, states that the husband must pay an agreed amount within 30 days in the event of divorce. 16 witnesses were listed on the reverse. This was not romance written on papyrus. It was risk management. Such agreements did not necessarily create the marriage itself. They helped define economic rights inside it. That distinction is crucial. A A couple might already be living as husband and wife, while the contract recorded what one party owed the other and what would happen if the relationship ended. Some agreements refer to support or to a marriage payment. Some protect the wife's claim to goods. Details differ by date and document, so there was no single standard Egyptian prenup. But the purpose feels modern. Remove uncertainty before a dispute begins. Suppose the couple owns a bed, stools, storage chests, linen, tools, grain, animals, and perhaps rights connected to a house or field. Which objects belong to the wife? Which belong to the husband? Which were acquired during the marriage? Egyptian records sometimes distinguish personal property from property accumulated by the household. Scholars have reconstructed arrangements in which the wife could claim her own goods and a share of jointly acquired wealth. In some New Kingdom evidence, a one-third share for the wife and two-thirds for the husband appears in discussions of marital property. But this should not be turned into a timeless national formula. The exact division depended on period, local practice, the origin of the property, and the documentation available. The most important point is simpler. Divorce did not automatically mean that the husband took everything. If a woman had brought goods into the marriage, inherited property from her family, or received property in her own name, she could have a claim independent of her husband. A written list could become powerful evidence. So could testimony from neighbors, relatives, workmen, or local officials. In a community where everyone knew who had delivered a chest, paid for a field, or inherited a house, memory itself could become part of the legal process. This is why scribes mattered. Literacy was limited, but written records allowed a household promise to survive after memories changed. A document might name the parties, describe the property, state an obligation, record a date by the reigning king, and list witnesses. It did not make disputes impossible. It made denial more difficult. At Deir el-Medina, the village of skilled workers who built royal tombs near Thebes, legal conflicts could be brought before a local council often called a QMBT. The people involved were not anonymous peasants. They were members of a close community of craftsmen, scribes, foremen, and families whose arguments sometimes survived on papyrus or flakes of limestone used as writing surfaces. These texts show law operating at human scale. People complained. Witnesses contradicted one another. Oaths were demanded. Settlements were negotiated. A person with a strong document did not always win instantly, and a person without one was not automatically helpless. Reputation, testimony, persistence, and social position all mattered. Divorce could therefore be legally possible and still socially painful. A separated woman might have property rights, but enforcing them could require family support and access to officials. A husband might owe compensation, but an obligation written in ink was not the same as money already paid. The surviving contracts show what people wanted to guarantee, and their very existence suggests what they feared could go wrong. After the property was divided, both former spouses could remarry. Divorce did not permanently exclude either person from respectable society. Serial marriages are known, and blended families created another difficult question: which children would inherit which property? That brings us to the Egyptian will. The modern word will is convenient, but Egyptian documents could take several forms. A person might make a transfer of property during life, issue a declaration about who should receive goods after death, assign an office, establish rights of use, or formally disinherit an heir from property the person controlled. The border between gift, settlement, and testament was not always identical to the border in modern law. Some of the oldest surviving documents commonly described as wills come from the Middle Kingdom town at Line. These records show people arranging the transfer of property, offices, and responsibilities within the family. In one deed, a man named Wa transferred property to his wife, Sheftu, and protected her right to occupy rooms and share his burial place. The document also appointed a guardian for his son. It is a compact example of estate planning, housing, property, burial, and care for a child addressed together. Another Middle Kingdom deed concerns Mary and his son in Tef. The transfer of an office was connected to the son's obligation to support his father in old age. Property did not move through a family only because someone died. It could be exchanged for continuing care. That expectation becomes dramatically clear centuries later in the story of Naunakhte. Naunakhte was a woman of Deir el-Medina during the 20th dynasty. She had children from 2 marriages and property of her own. In her old age, she judged that some of her children had cared for her while others had neglected her. She appeared before local officials and made a declaration that has survived. Her message was blunt. The children who had supported her would receive what she controlled. Those who had failed to care for her would not receive her property. This is often summarized by saying that Naunakhte disinherited several of her children. That is true, but it needs one major qualification. She could dispose of her own share. She could not simply erase rights they held in property inherited from their father. Her declaration reveals both power and limits. A mother could use inheritance as a sanction, but only over the estate that was legally hers to distribute. The case is remarkable not because Naunakhte behaved like a modern millionaire rewriting a will. It is remarkable because an elderly Egyptian woman publicly evaluated her children's conduct and used property to reward care. For her, inheritance was not merely blood. It was reciprocity. Children were expected to support aging parents. Parents, in turn, could use transfers and inheritance to secure that support. The family was an emotional unit, but it was also the nearest thing many people had to a pension system. When children failed, the consequences could be written into the estate. What if a man wanted his wife to inherit, but ordinary family claims threatened her position? One extraordinary New Kingdom document describes a childless man formally making his wife his daughter so that she could inherit his estate. The language sounds strange to modern ears, but its legal function was practical. By placing her in the position of an heir, he attempted to protect her from claims by his brothers and sisters. This was not adoption in the modern emotional sense. It was a legal strategy. Egyptian families could reshape recognized relationships to direct property toward the person they wanted to protect. The same flexibility could produce conflict. Houses might be divided into shares. Children from different marriages might possess different claims. A widow might control her own property, use part of a house, and manage assets for children, while relatives argued over what had belonged to the deceased husband. An office could sometimes pass like property, especially when it provided income and status. Farmland, movable goods, servants in periods when servitude existed, and rights to income could all appear in transfers. Not every Egyptian could leave behind a grand papyrus. Writing required a scribe, and preservation depended on accident. Most ordinary legal arrangements vanished. The documents we possess are therefore not a complete national archive. Places such as dry desert settlements preserve material far better than the damp agricultural zones where most Egyptians lived. Even the word property hides uncomfortable realities. Some ancient documents transferred dependent people as assets. Egyptian society was hierarchical, and legal capacity was not equality. Wealth, status, gender, occupation, and family connections shaped whose claims could be heard and enforced. Recognizing the sophistication of Egyptian legal practice should never turn it into a fantasy of modern justice. Yet the records do overturn a common stereotype. Ancient Egyptian women were not universally treated as the property of their husbands. A wife could have her own economic identity. A marriage could end without either spouse being permanently trapped. A widow could receive protection through a transfer. A mother could decide that neglectful children did not deserve her share of the family wealth. So how might the complete process have looked for one hypothetical household? Picture a craftsman and his wife in a New Kingdom town. When they form a household, she brings linen, jewelry, and a storage chest from her family. He brings tools and a claim connected to his work. Over the years, they obtain furniture, grain, and perhaps a share of a house. Their neighbors know where many of these things came from. A scribe records at least some obligations. Then the marriage fails. One spouse leaves. The families negotiate. The wife demands the return of her goods and her recognized share of the household property. The husband disputes the ownership of a chest. Witnesses remember who delivered it. A local council hears the complaint. An oath or document settles the point. If a later contract applies, compensation or support may also be due. Once the separation is recognized and the claims are resolved, each person can form another household. Years later, the children of those different marriages face inheritance questions. Their father may transfer an office to the child who promises to support him. Their mother may preserve her own goods for the children who cared for her. A surviving spouse may need a special transfer to remain in the home. What looks from a distance like family property becomes a web of personal shares, agreements, obligations, and memories. This reconstruction combines patterns from different surviving records, not one universal case. But it captures the central logic of Egyptian household law. Define who owns what, record important promises, call witnesses, and link property to responsibility. The Egyptians knew that death could create chaos among the living. Their wills and transfers were attempts to control that chaos. They knew that marriage could fail. Their settlements were attempts to make separation survivable. And they knew that family loyalty could not always be assumed. Sometimes loyalty had to be rewarded or its absence punished. There is a final irony here. The civilization famous for building monuments meant to last forever left behind intimate records of relationships that did not. A marriage ended. A child disappointed a parent. A widow feared losing her home. A husband tried to protect his wife from his own relatives. These problems were written on fragile papyrus and broken pieces of limestone. Yet some of those words outlived temples. Ancient Egyptian divorce was not modern divorce. Property division was not governed by one unchanging formula. A will might be a lifetime transfer, a formal declaration, or a strategy built around family status. But the people behind these documents are immediately recognizable. They wanted control over what they had earned. They wanted protection when love failed. They wanted care in old age. And they wanted the final word on who deserved what they left behind. The pyramids tell us how kings imagined eternity. These legal records tell us how ordinary Egyptians survived one another.